Hello everyone, my name is Matthew S. Weidman, and I'm an attorney based out of St. Louis, Missouri. I've been practicing law for a little over 5 years, and one of the main focuses of my practice is landlord-tenant law. I do a lot of research on this topic, always trying to stay ahead of trends and new changes in the law. And what I was struck with, especially in YouTube, is there's very little information regarding this topic on YouTube. So I decided I'd make a top 5 mistakes I see my clients make in hopes that this will help somebody in the future, or it can help a new person see where some issues could be when they start this business out. Because this is a very tough business to get into. Even it's very tough regional law to get into as well. Some of this stuff may seem very obvious and kind of silly, but you would be surprised how many times people come into me with help and these issues constantly come up into one. And that being adding a pest provision and a utilities provision. You need to make sure your lease agreement states that the tenant is responsible for pest control. The reason being, pest control can be very, very expensive. If a child brings home bed bugs from a daycare system, it can cost upwards of $5,000. Now that's for multiple treatments, but I've seen single treatments cost as much as $2,500. Second part is utilities. Make a provision in your lease that states they are to pay all of the utilities. Make sure it specifically states what they are to pay. It specifically states use utilities like water and electricity and gas. I have seen far too many times where landlords have shown up to consultations and there's no provision for utilities. The tenants run $400 worth of gas bills, and if the gas company won't let them cut it out of there, won't let them cut the gas off. When we go to trial and we try to seek that money back at trial for use, the tenant says, "Well, I was told that it included gas, it included electricity." And then it's a he said, she said situation, and sometimes the judge won't give my client the money back. My client's out $400 or $500 on top of not getting rent and on top of paying me. And the pest situation, another one too, which you'll see oftentimes in urban places like St. Louis City or St. Louis County. The tenant will bring proof that there are roaches and mice in the property, arguing that the property is not habitable. Judges sometimes will listen to this, and the counter argument that my client may give is that, well, they brought the roaches, they brought the rats. And the tenant's going to say, well, the landlord didn't do anything to fix it. Without a provision in your lease saying that this is to be cleaned or taken care of by the tenant, the landlord sometimes can lose money. And I've seen in cases where the judge has said, this place is overrun by cockroaches, so I'm going to give the tenant $500 off their back rent. So you always want to make sure those two provisions are in there. That way you can save yourself some time and some serious money. That's very important, and it's something most provisions, leases do carry that, and that's true. But it's something if you know someone who doesn't have that in their lease, they need to put that in there as soon as. Number 4, evicting tenants during the holiday season. Now this seems like a silly, maybe only like attorneys would know this situation, but judges, sheriffs, clerks all like to go on vacation too. And they build their vacation near holidays so you can have an extended vacation. So what you'll often see is that there are no court dates between November and January 1st. Now, I mean, there's not no court dates, but there are very limited court dates. And also, your support staff that carry out evictions are not going to show up, or not going to be available because they're on vacation. So I had a great example of this. I had a client, we tried the case, and I got a judgment November 28th. November 18th. November 18th. I got the judgment approved November 28th. The sheriff gave me an eviction date of January 5th. So So the tenant got to stay in there for a month and basically 8 days. By the time my client got the property back, the property was destroyed by a pipe break. So you must understand, you got to make some decisions before the holidays. That way you give yourself the most flexibility and payment scheduling and getting a tenant out and setting court dates. And also for yourself, you may not want to try a case and show up to court with your lawyer a couple days before Christmas or a couple days after Thanksgiving. You may want to have that time with your family. So it's very important, and this just seems like it's not really a matter of law, but just a matter of common sense, that you make some hard and fast decisions before the holidays. Otherwise, in these larger jurisdictions like St. Louis City and St. Louis County, and I would probably imagine Kansas City, you are going to be stuck with that tenant until the courts can take action on your behalf. And no lawyer in the planet can make a judge come back. Waiver of trial by jury. Now, generally in Missouri, and there's case law to back this up, landlord-tenant actions are not jury tried. They are tried by a bench trial through a judge. If anyone had experience with this, it's a rather quick affair. Sometimes these trials can last maybe 30 minutes, 25 minutes, and they're much easier to schedule. A judge can typically have 4 or 5, I've even seen 9 trials in front of one judge in a morning docket. What that means is you get the whole process of whether or not your tenant owes you money, if you owe the tenant money, you get that whole process over quicker. What I still say is there needs to be a waiver of trial by jury in your lease. The reason being, there are new judges. There are judges in rural counties who don't necessarily always understand that these are quick matters. And they will sometimes grant a trial by jury. What that means is it takes almost an entire day to pick a jury. And it can be more expensive for my clients because they have to pay me to do voir dire, which is select the jury. They have to pay me for a trial strategy. It's a whole other setup to convince jurors who are not familiar with the law, with the way rent possession case goes or an unlawful detainer case goes. Totally different. It's a much greater cost. Consequently, it may take 2 days to have a jury trial, because I would assume the other party, as an attorney, or if it's a pro se person, that means they're being represented by themselves. They're rambling often. It's often kind of difficult to keep them on task, and it takes a long time because they want to bring up everything they could ever think of. So you want to have a waiver of trial by jury. Also, there may be some ancillary issues in a rent possession case that may be brought up that maybe don't have necessarily to do with the rent possession. Maybe an injury on the property. Maybe a dispute over property left over at the apartment. That could still potentially be a jury trial. So it's just good to have a waiver of trial by jury. Some people may say, hey, maybe, as a landlord, maybe you want it. That may be some specific strategy. In my experience and what I've seen with clients, you want to have some sort of provision that way. I don't see too many of them in a lot of leases that I run across, but it's a good idea to find a lease with that, or to hire an attorney to produce a clause for you to protect you in the long run. And that's a simple. It seems like a no-brainer in a lot of places. A lot of things have no trial by jury. They have a waiver of trial by jury in almost everything you see, especially a lot of times in Missouri. But it's very important to have that, and it seems like a lot of people don't have that in their lease. Number 2, evicting tenants while in bankruptcy. Now this one could probably be number 1, just based upon the risk and the problems that it can cause and the cost it can cause to your average landlord. I only put it as number 2 because I only see it 3 or 4 times where a landlord has actually tried to evict the tenant while they're in bankruptcy. Most people understand that a bankruptcy is pretty serious, that they need to consult an attorney when their tenant files for bankruptcy. But every once in a while, I'll have somebody come to me where the dumpster's already on fire and I have to figure this out for them. But number 1, you cannot file a eviction on a bankruptcy case. You just cannot. There is a automatic stay that comes anytime someone files bankruptcy. That means the bankruptcy court has to give you permission to collect the debt and to evict the tenant. So what a landlord would have to do is hire an attorney who's competent and admitted in the bankruptcy bar, lift the automatic stay, which is a fairly expensive proposition. Once it's been lifted or granted by the court can always say no. The bankruptcy court is quite jealous in its jurisdiction and is always kind of trying to look out for the debtor and maybe not so much for the landlord. After a motion to lift the automatic stay is granted, then a landlord may evict the tenant in a possession only. Now, this can add, I've seen it once, 6 months of time, because a motion has to be drafted in bankruptcy court. The filing fees have to be paid. Then there has to be a time to hear the motion in bankruptcy court. Once that is held, they either make a decision, they say yes, they say no. Then they say yes, you must go to state court, and then you have to have your initial hearing, and then you may even have to have a trial. So it can add a lot of time. Consequently, the problems for a person for knowingly filing an eviction during a bankruptcy are substantial. And I would invite you to look that up yourself. You could probably Google, I can speak it much better than I could, but I would Google problems or consequences of filing for an eviction during a bankruptcy. Let alone, I mean, every attorney's got a horror story of hearing about some attorney or some person who filed an eviction during a bankruptcy and didn't listen and was hauled in front of federal court and read the Riot Act and had to pay some ungodly fine over this. So this is a number one issue. Could likely be a number one issue. Like I said, I don't see it much. A lot of my clients don't have tenants that file bankruptcy regularly, or if they do, they tend to just vacate the property by the time they don't have the money. But it's very, very serious, and something I cannot stress enough when I talk to my tenants or my clients, that this has to be dealt a certain way and can be very potentially time wasting and ruinous for the landlord who doesn't consider how important that is, or it doesn't realize where they are in the process of bankruptcy. Now, there has to be, typically in a bankruptcy situation, when the creditor has to get notice that there's a debt, that the debtor has filed bankruptcy. So it should be fairly obvious this is going on. Now, like I said, I've seen a couple clients who have, despite this, still filed. You have to watch that. Anything filed in state court while bankruptcy is going on is void. So it means nothing, and all it does is cause you problems and trouble. And the number one biggest mistake I see my clients make in these situations is they do not know their own lease. You must know your lease backwards and forwards. You must understand its strong points and its weak points. If you're like many of my clients out there, this house or this extra property is their retirement money. It's a great source of income coming in. It's very important that they know what this lease is. I cannot tell you how many times I've seen tenant or clients with $150,000 homes, $200,000 homes with 5-page lease agreements. Now, the quality of the lease agreement does not depend on the page limit you have, but you typically want to have more words in there to take care of more situations that may come up. And a lease agreement is a bit like a prenuptial agreement. It controls the way the relationship ends just as much as it controls the way it flows. So you want to make sure you want to have a position for for damages, so that if your tenant reneges on something, that you can actually get financial compensation for their breach of the contract. You also want to make sure that the tenant initials each page and that they provide a driver's license. That way, you can prove who lives at the property. what I oftentimes I see is that a bad tenant moves in 4 other bad relatives or bad people that you do not know. The next thing you know, your tenant, this is a fairly true story, has moved a child molester into a neighborhood that you do not want. And he's on the lease agreement, and yet he acts like he lives there. You need to be able to exclude people you don't know from this. The next issue I think too is a lot of times there's Missouri specific provisions in a contract. You can't show up to a Missouri case with an Illinois lease agreement, which I have seen. It doesn't help. Might as well be written in Chinese. It means nothing. So what you need to do is make sure there's certain provisions that are in accordance with Missouri law. You need to have a lead-based paint addendum, which is federal law. You need to have that in your lease agreement. That is just common sense, no-brainer. I would have that attached. I would also have a walkthrough attached. Some of my clients will have a piece of paper just noting issues at a property. That way, a tenant cannot say later on, there's a hole in the wall, that you moved in there with a hole in the wall. I would take pictures and attach them to the lease. Some people have software that you can attach the pictures of the move-in day with the lease agreement. But it's very important that you understand your lease and that you have a lease that's tailored to what you're doing. But multifamily homes need to have a different lease agreement than single-family homes. It's specifically when it comes to taking the trash out. I've seen single-family homes where only 3/4 of people take the trash out, and you have to kind of get the client has to get on that person to remove them. So what they need to do is they create a fine schedule. They say, look, if you don't do this, or if you don't take your trash out, you don't take your recyclable bin out, you let your dog poop in the yard without cleaning up the mess, you will then have to pay this much every time I catch you. Also, if a client does a security deposit, you need to make sure that there's a schedule in there, and you say up front what the cost of things are. Like the cleaning of an apartment is $125. The fixing of nail holes is $10. The removal of cigarette butts outside the backyard is $1 per cigarette butt. That way, there is no argument about how much things cost, and you don't have to go to court and disagree. Obviously, that provision of the agreement has to be written by a lawyer in accordance with Missouri law. So there is no. You're going to need to consult a lawyer about your schedule, but the point of that whole discussion is that it needs to be tailored for what you're doing. Nice clothes, just like lease agreements, need to be tailored. Otherwise, it doesn't fit. And this, like I said, this seems like the easiest one, but you'd be very, very surprised and kind of amazed at how many people show up with, and I've heard this before, well, my brother got it from this guy, and he thinks it's pretty good, and he uses it at his properties, and the clients have no idea what's in it, what they're agreeing to, what they're not agreeing to. And that's what goes along with the pest control and utilities provision. That technically can be a part of it, but a lot of people are using standard leases from one of the realtor associations in the state of Missouri, and they have some standard clauses that I probably think aren't always included, but sometimes they are, and you may want to be aware of those. That's why I highlighted that in one of the numbers of this mistakes. Folks, this is a very important and difficult area of the law, and it's very litigious, so you need to be aware of what's in that lease, because it can get you sued. And I would consult with an attorney immediately if you have any questions about your lease. Remember, and there's a disclaimer part, the choice of a lawyer is very important, and it should not be based upon advertisements or a video like this. Past issues that I've talked about or I will talk about have no bearing on future performance. This video in no way creates or offers an attorney-client relationship. Matthew Weidman LLC owns the intellectual property of this video, and it shall not be distributed without my written permission. This is not legal advice. Legal advice you must pay for. This is helpful information. If you have any questions or would like to discuss your current situation, please do not hesitate to contact me. My contact information on this page.